एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए.
A very warm welcome to all our viewers on this virtual judicature series. Today we have with us Advocate Swati Kamat Wagh, who will be speaking on the topic Right to Information Act 2005. Swati Kamat Wagh is a practicing advocate since 1998. Presently, she is on panel of Goa State Legal Services Authority as a legal aid advocate. Now I request Advocate Swati Kamat Wagh to take over the session.
Today's topic is Right to Information Act 2005, which we commonly refer to as RTI Act. Before I take you all through the RTI Act, I wish to give you a short history, objective and introduction of the Act so that we understand the provisions along with the background features. Right to information has been categorized as fundamental right under Article 19(1) of Indian Constitution by the Supreme Court to question and to hold the government accountable for its functions. When there is a right, there is a remedy provided to enforce this right, and hence the RTI Act helps in exercising this right and to enforce the remedy. Coming to historical background of this Act, the Right to Information Act gained power when Universal Declaration of Human Rights was adopted in the year 1948, providing everyone the right to see, receive information and ideas through any media and regardless of frontiers. The Right to Information Act gained power when Universal Declaration of Human Rights was adopted in the year 1948, providing everyone the right to see, receive information and ideas through any media and regardless of frontiers. The information is the currency of democracy and critical to the emergence and development of a vibrant society. However, with a view to set up a practical regime for the citizens to secure information as a matter of right, the Indian Parliament enacted the Right to Information Act 2005. Genesis of RTI law started in the year 1986 through the judgment of Supreme Court in the case of Mr. Kulwal versus Jaipur Municipal Corporation case, in which it was directed by the court that freedom of speech and expression provided under Article 90 of the Constitution clearly implies that the right to information, as without information, the freedom of speech and expression cannot be fully used by the citizens. Objectives of the RTI Act are to empower the citizens by providing information as suit, to promote transparency and accountability, to curtail corruption, and to enhance people's participation in democratic process. Right to Information Act mandates timely response to citizens' requests for government information. It is an initiative taken by the Department of Personnel and Training, Ministry of Personnel, Public Grievance, and to provide a RTI portal gateway to the citizens for quick search of information on the details of first appellate authorities, PIOs, etc., amongst others. Besides, access to RTI related information, disclosures published on the website of various public authorities under the Government of India as well as the state government. Important provisions under the Right to Information Act are Section 2H, which describes public authorities, which means all authorities and bodies under the Union Government, state government or local bodies. The civil societies that are substantially funded directly or indirectly by the public funds also fall within the ambit of RTI. Section 4(1)(b), government has to maintain and proactively disclose information. Section 6 prescribes a simple procedure for securing information. Section 7 prescribes a time frame for providing information by the PIOs. Section 8, only minimum information exempted from disclosure. Section 8(1) mentions exemptions against furnishing information under the RTI Act. Section 8(2) provides for disclosure of information exempted under the Official Secrets Act 1923 if the larger public interest is served. Section 19, two-tier mechanism for appeal. Section 20 provides penalties in case of failure to provide information on time, incorrect, incomplete, or misleading or distorted information. Section 23 lower courts are barred from entertaining suits or application. However, the writ jurisdiction of the Supreme Court of India and High Courts of all states under Article 32 and 226 of the Constitution remains unaffected. Coming to the significance of RTI Act. The RTI Act 2005 empowers the citizen to question the secrecy and abuse of power practiced in the governance. It is through the information commissioners at the central and the state levels that access to such information is provided. The RTI information can be regarded as a public good, for it is relevant to the interests of citizens and is crucial pillar of functioning of a transparent and vibrant democracy. The information obtained not only helps in making government accountable but also useful for other purposes which would serve the overall interests of the society. Every year, around 6 million applications are filed under the RTI Act, making it the most extensively used sunshine legislation globally. These applications seek information on a range of issues, from holding the government accountable for the delivery of basic rights and entitlements to the questioning of the highest offices of the country. Using the RTI Act, people have sought information that governments would not like to reveal, as it may expose corruption, human rights violation and wrongdoings by the state. The access to the information about policies, decisions and actions of the government that affects the lives of the citizen is an instrument to ensure accountability. The Supreme Court has in several judgments held that RTI is a fundamental right flowing from Article 19 and 21 of the Constitution, which guarantee to citizens the freedom of speech and expression and the right to life respectively. For information of general public, I would like to just state here that RTI Act did not create a new bureaucracy for implementing the law. Instead, it tasked and mandated officials in every office to change their attitude and duty from one of secrecy to one of sharing and openness. It carefully and deliberately empowered the Information Commission to be the highest authority in the country, with the mandate to order any office in the country to provide information as per the provisions of the Act. And it empowered the Commission to fine any official who did not follow the mandate. Right to information has been seen as the key to strengthening participatory democracy and ushering in public-centered governance. Access to information can empower the poor and the weaker sections of the society to demand and get information about the public policies and actions, thereby leading to their welfare. It showed an early promise by exposing wrongdoings at high places, such as in the organization of Commonwealth Games and the allocation of 2G spectrum and coal blocks. Right to information opens up government's records to public scrutiny, thereby aiming citizens with a vital tool to inform them about what the government and how effectively, thus making the government more accountable. Improves decision making by public authority by removing unnecessary secrecy. Now, with this backdrop, I will take you all through the contents of the Act so that we understand it from a right perspective. Right to Information Act 2005 is a central legislation. Under this, information means records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material in any electronic form, information relating to any private body which can be accessed by a public authority. Record means documents, files, manuscript, microfilm, fax, reproduction of film, or images embodied in such film, any other material produced by a computer or an electronic device. Right to information means inspection of works, documents and records, taking notes, extracts, certified documents of the records, taking certified copies of sample of materials, obtaining information in the form of discs, floppies, tapes, video cassettes, or in any electronic mode, or through printouts where such information is stored in a computer or in any device. Information which is exempted under the RTI Act is the information which will prejudicially affect sovereignty and integrity of India, security, strategic, scientific, economic interest of the state, relation with foreign state, information which might incite an offence, information which is forbidden by the court, that causes a breach of privilege of the legislature, would harm the competitive position of a third party, is held in fiduciary relationship unless larger public interest warrants disclosure. Information that is held in fiduciary relationship unless larger public interest warrant disclosure is also exempted. Information that is received in confidence from foreign government is exempted. Information that would endanger the life of any person, that is also exempted. Any information that would impede the process of investigation would involve an infringement of copyright, personal information which has no relationship with any public activity or interest. Cabinet papers, including records of deliberations of the Council of Ministers, Secretaries and Officers, are also exempted. Please note that it's not that when you apply under the RTI, then only you get information. There is something called as proactive disclosure under the RTI Act, which means that every public authority must proactively disclose particulars of the organization, its functions and duties, procedure followed in its decision-making process, norms set out for the discharge of its functions, rules, regulations, instructions, manuals and reports used by the employees for the discharge of his function. Which means that today if you see any website of any official website of any government organization, you will prima facie see all the information at the first instance itself, for which you need not obtain the information under the RTI Act separately, because the government has already disclosed this information on their website. The Act also provides an obligation on all public authorities to designate a public information officer to provide information to all the applicants within its departments. Also to designate assistant public PIOs at sub-divisional district levels. No, there is no bar as far as the number of these PIOs or assistant PIOs are concerned. The Act also puts an obligation to designate appellate authority for the first appeal within the public authority. There is a procedure prescribed under the Act for seeking information. One has to make an application in writing, including through electronic mediums or in any language, in English or Hindi or local official language of the area, which means that any person can obtain information. It is not necessary that you should know English only. Hence, this Act is reaching to masses and more particularly to our village India. Secondly, when there is information is not in writing, PRO has to provide assistance to reduce it to writing, so that one understands in a normal simple language. Reasons for seeking information need not be stated. In your application, you have to simply state that you are a citizen of India and you are seeking particular information, either documentary or otherwise. RTI also prescribes fees for obtaining information. The fees prescribed by the central government are: for supply of information, application fee is ₹10. Cost of stationery is ₹10 each page of the information in A4 or A3 size of the paper, and actual cost of the information upon printing, xerox, etc. Cost per floppy and or CD is ₹50. For inspection of record, no fees are first hour are charged. However, ₹5 for every subsequent hour and fraction thereof. The Act also provides for time period within which the information has to be supplied. Information should be supplied within 30 days from the date of the application. 48 hours if it involves the life or liberty. 40 days if it involves the interest of third party. If no information is given by the public authority on RTI application within the time limit as stated, then the same is to be treated as deemed to be refused. Also provide appeals if there is no information provided, or if the information provided is not sufficient, or set as the applicant is not satisfied with the information that he has received, in which case there are two stages of preferring appeal. In the first stage, it is known as first appeal, which is an internal appeal, which is made to the officer immediately senior to public information officer within 30 days of the decision. Appeal to be disposed of by the officer within a period of 30 days, extendable up to a total of 45 days. When it comes to external appeal, it is called a second appeal, which is made to CIC, which is Central Information Commission, and or to SIC, which is State Information Commission, within 90 days of the decision of the appellate authority. In both the appeals, onus of denial of the request shall be on the PIO. The decision of CIC or SIC is final and binding. Now coming to imposition of penalties. Public authority is liable to fine ₹250 per day up to maximum of 25,000 for not accepting an application, delaying information released without reasonable cause, malafidely denying information, knowingly giving incomplete, incorrect or misleading information, destroying information that has been requested, or obstructing furnishing of information in any manner. CIC or SIC empowered to impose penalty on PIO. They can also recommend disciplinary action against a PIO. Hence, in conclusion, we can state that if you see the entire import of the Act, it is meant to empower every citizen of our country, so that with this information we can do social justice to all our countrymen. Hence, it is very important that the information sought is appropriately used and is used for the benefit, progress of the country and the state. With this, I thank Learned Member Secretary, Goa State Legal Service Authority, for providing me this opportunity, for giving this talk on Right to Information Act 2005.
On behalf of Goa State Legal Services Authority, I thank Advocate Swati Kamat Wagh for enlightening our viewers on topic Right to Information Act. Thank you, madam. I also request all our viewers to like this video, share this video, and also to subscribe to our channel. Thank you.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळोवन दिता.
वेळार योग्य कायद्या खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चड काळच्या केसीक बेगीन सोपयता
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय, बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करात
वा टोल फ्री नंबर 151000 चेर फोन करात.